Thank you. Ms Seedat, I've been asked to make it clear that before the first letter to Lord Jenkins, the point that we raised about them not referring to the GEB files, that very first letter to Lord Jenkins, before you wrote that very first letter, you had received an email from Anita James referring to the audit report, but in your witness statement you say you may not have appreciated the significance of it until November 2005
That's
when
correct.
you requested a copy of it.
Right.
Picking up again on the freedom of information requests. And at the end of March 2005, you provided a reply to another FOI request in much the same terms as you had in the reply we looked at before the break. But on this occasion, one of the FOI team queried it, and I want to look at that. WITN 4912036, please. The query is at the bottom of the page. I'm concerned that the answer put forward by Zubeda Seedat would be difficult for Mr Z to accept, given this was a discovery claim to support an extensive litigation case. May I suggest that you contact Sol to see whether they have the records, the documents which were provided for the judge and the appeal court. It may be a good idea to clear your answer with them also. If Sol do not have the documents, can we be sure that some, if not all, are not on archive, either at Nelson, the National Archive, or with the Department Records Office? If you do find the documents, it may be that the £600 limit would be breached in redacting them. If that's the case, please let me know and we can discuss how to handle. Were you made aware of this email at the time? I think you were copied in.
I think I may have been on leave at the time. It may have come in.
The email at the end of the document suggests you were going on leave.
Right, okay. I mean, I can't recall. So it was addressed to Michelle and William. I don't know if I would have been copied in.
We can see that, we can see that you're copied in.
Okay, right.
But you were on leave that day. I just meant around that time, were you made aware of this query that had arisen over whether the response was quite right?
I wouldn't be able to remember.
And do you remember whether any steps were taken in relation to going and checking the storage, or?
I can't remember. I don't want to speculate on that. I can't remember.
And if we turn then to WITN 4912037, please.
Although, sorry, can I just say, at this point, I think there might have been references prior to this where I'd been trying to find papers from DRO. Mm-hmm. So it's possible I may already have looked at previous files. So, yeah.
And if we pick up the reply from Sol, middle of the paragraph, Michelle, my colleague Ronald Powell had conducted the litigation all those years ago. Once the litigation was finished, the files were sent to remote storage. About 6 years ago, I looked for them in relation to another case we had and was unable to retrieve them because they'd been destroyed. Department of Health records, as opposed to ours, were inadvertently destroyed in the early 90s. As the HEO working in the branch had given them a ridiculously short destruction date, I'd take out the do not appear stuff. There are no records. And we see then that this is provided to you by Michelle Hewitt. William asked me to contact Sol regarding this FOI case. They wanted us to check with them to see if they had any records, and these are their comments. Do you remember any further discussion about this particular issue?
I don't know.
We have your response after you come back from leave, just to tie up the jigsaw. WITN 4912038.
Can I just ask a question? The answer by Michelle Haywood, the third sentence, once the litigation was finished, the files were sent to remote storage. Now that's
it's from Mrs. James to Michelle Haywood.
From Mrs. James. So she appears to be under the impression at this stage that the files are sent to the appropriate records office for remote storage, as opposed to there being some failure to archive properly. I don't quite sure how the two fit up. Can you give any help at all on that?
I mean, obviously from this memo, Anita is saying it's Department of Health records, but I don't know, I vaguely recall that in the previous advice to me, Anita may have said that after the litigation, I don't know if it was that the papers had been held by Sol, I can't remember. I don't know if there is a distinction between the two, I can't.
Sorry, so I'm just looking for an earlier document that might assist. It's not the document I was thinking of, but Mr. Moss has very helpfully flagged the document we looked at the very beginning of my questions. DHSC 0020720, where Mr. Lister had informed Ms. Seedat that the documents have been destroyed in a clear out by Sol.
Yes, the clear out by Sol is not, I would have thought, quite the same thing as an assertion that the files were sent to remote storage.
Indeed.
It may be clearing them out of the office, but they go into remote storage, as opposed to clear out and destroying as you go, shoving them in the waste bin. But
I can certainly check over the lunch adjournment or the next short break we have, whether there is anything earlier that deals with remote storage. I can't put my finger on anything at this moment in time.
I mean, it just adds confusion to an already unclear picture.
If we can then pick up your reply after you came back from leave, WITN 4912038. Second page, please. You've written, I was on leave last week, so apologies for the delay in replying further to the comments by Chris. I can confirm we did contact colleagues in Sol about this case. It's both our understanding and theirs that the papers that were subject to public interest immunity claim have been destroyed. Sol confirmed that about 6 years ago they looked for these papers in relation to another litigation case they had and were unable to locate the papers because they've been destroyed. So that was your response, just to tie up that part. There were continuing questions about documents, and I want to pick it up now in December 2005. Charles Clarke MP wrote to Patricia Hewitt, the then Secretary of State, asking about departmental files and sought the certificate of destruction for the ACVSB documents. You were tasked, I think, with addressing his question, and you made contact with Roseanne Pratt, Records and Information Services Manager. If we can look at her reply to your queries, DHSC 0200107, please. And it's page 2. And she writes this, in fact, to a colleague, but it eventually gets to you. We keep certificates of destruction on a working file at DRO Nelson, but I doubt there'd be any useful purpose served by anyone having sight of them, as they only state that an amount in weight has been collected from us on a particular date and received by the recyclers and destroyed. As I said previously, it forms part of the audit trail, but does not give any specific details of individual files that have been destroyed. Do you have any understanding of why the weight of documents is required and not the reference of the files?
I don't, I'm afraid, no.
Or how it makes any sense if it's an audit trail?
Would that have played any part in your role?
I don't know, and I think I said in my witness statement that that would be an issue for the team that looks after policy on departmental records rather than a policy team.
Now, simply as a marker, at a much later date, July 2007, destruction dockets from the files, the decision to go to for destruction, were provided. But that's a different thing, I think, to the certificate of destruction. Is that right?
That's correct.
Then if we can turn to WITN 3996023. We have the reply from Patricia Hewitt to Charles Clark, and we pick it up in paragraph 3. Mr. X asks specifically why, and sorry, let me start again. She is responding to his earlier correspondence, and the constituent had raised questions about Sir Nigel Crisp's letter to Lord Jenkin. Paragraph 3, Mr. X asks specifically why an inexperienced member of staff was allowed to make decisions to destroy important papers. The plain answer is that we do not know enough about what happened to answer that question. Clearly the papers should not have been destroyed. I'm very sorry that they were. When the records in question were destroyed, the general guidance on records management was broadly the same as it is today. Departments are obliged under the terms of the Public Records Act 1958 to identify records needing long-term retention, while destroying most of their records as soon as their administrative value ends. Decisions on retention and destruction of records should always be made by individuals with knowledge of the content and likely future importance of the records. The guidance current when the records were transferred to the Departmental Record Office stated that decisions on retention or destruction of departmental files should be made by an officer of at least executive officer grade, who was appointed by senior officers who are satisfied that the officer is sufficiently aware of the administrative needs of the section to be able to make the decisions. A decision to destroy a file was appropriate when files either had no further administrative value at all or only a short-term administrative need. Files marked for destruction would have been destroyed by the Departmental Record Office either 2 or 5 years after the date of the last paper on the file. The appropriate decision for the records we are discussing would have been to retain the records for review after 25 years, when a further decision would be made whether to destroy or retain the files. After 25 years, we would only retain files if they had historical or continuing administrative value. These particular records were destroyed between 1994 and 1998, in line with instructions written on the file by a member of the policy team when the records were transferred to the archive 3 or 4 years before. Sir Nigel's letter made it clear that the records should not have been destroyed. I do not believe we can go further in examining the causes of the mistake. First of all, what involvement did you have in drafting that reply?
I'm not sure if I did draft this, or if I had, it would have had a huge contribution from the team that provides policy on holding of departmental records, because it kind of talks very specific about the whole area of the policy, so it wouldn't necessarily be something I would have written. I think it would have come from somebody else. But I'm not sure if I was responsible for coordinating a response, or whether in fact somebody else, i.e. somebody, the team looking after departmental records, whether they provided the response. And because at this point they were engaged certainly in the whole issue around the destruction of documents, so it's a possibility I was involved, but if I had been, most of that contribution would have come from somebody else.
Just 2 points arising from the letter I wonder if you can assist us with. There is reference here that decisions on... Sorry, if we go back a page, please, Lawrence, at the bottom of the page. Decisions on retention and destruction of records should always be made by individuals with knowledge of the content and likely future importance of the records. And it also goes on to say it should be someone of at least executive officer grade. In your experience, would an executive officer have the requisite knowledge to really know whether something would be of likely future importance?
I would disagree with that. I think it has to be somebody at HEO, SEO level. I think I'd said before that at EO level, you're not necessarily involved in or engaged in all the nuances of a particular policy and kind of engagement and the types of records that would be on there. I think it's a fairly junior grade, and I think that was acknowledged in the audit report as well.
And secondly, before this letter went out, were you asked to do anything further to try and identify any of the documents or investigate anything more about their whereabouts?
So what year, can you just pull back
Yes.
the date for me, please?
It's February 2006.
At this point, I don't think so. I can't recall.
So do you remember any discussion, if we go over to page 2, about the sentence that's been put in paragraph 4, I do not believe we can go further in examining the causes of the mistake?
I mean, we kind of had information about the destruction of the two sets of documents. I think, in my view, reading this year, at this point in time, I don't think that there was anything further that we could have done.
Moving forwards then to February 2006, you emailed Steve Wells about some parliamentary questions on document destruction.
Can I just raise one question before we go there? Just looking at that last document, the paragraph which begins, these particular records were destroyed between 1994 and 1998, in line with instructions written on the file by a member of the policy team when the records were transferred to the archive 3 or 4 years before. So that would mean the indication to destroy would have been written sometime in 1991 or to 1994.
These are the second stage of the GEB files.
Yes. Does this fit with the other documentation which we have in respect of the particular files showing the dates when they were marked for destruction?
I would need to go back to the destruction dockets.
Deal with it in due course. It's just a question from me.
Yes.
Just wondering about whether that's an accurate phrase or not. It may be, it may not be.
I think I may be able to deal with it if you just give me one moment, because we have the dockets available to us. No, so I think I need to take a little bit more time before I respond on that.
No, it's not for Zubeda Seedat to deal with, because it plainly the information didn't come from her. But,
we have the dockets, sir, and I can just double check those dates.
Yes, thank you.
Steve Wells, you emailed him in February 2006. Could we have DHSC 5402137, please? We can see at the bottom of this page his email footer as being freedom of information, records and data protection. Then if we go over the page, we can see he's the consultations coordinator. Can you help us with what his role was?
So I think Steve worked in the team that essentially had the policy around document retention, giving advice to staff within the department on that, and it would obviously appear from his footer a role in terms of FOI cases as well.
And your email reads as follows: I'd be grateful for your advice, comments on 2 PQs, parliamentary questions, that we've received about the destruction of papers. Given that this has become an issue, I think it would be helpful if we could try to draw up a list of files on blood safety that we do hold by subject area, i.e. committees, finance, briefings, PQs, imported plasma, etc., going back to the 1970s and 1980s. It makes us vulnerable to say that we are aware of papers that have been destroyed without having a clear understanding of what we do hold. When we met last week, I mentioned that we're not resourced to undertake detailed inquiries about past papers. I wondered whether you'd be able to identify someone to help out so that we could establish what files exist. Grateful for your views on this approach. At present, it's difficult to assess if this issue will quieten down. Can you explain for us why it was February 2006 that you sought his advice, rather than perhaps earlier when you'd had a lot of PQs then as well?
I can't at this point in time. I perhaps should have sought advice earlier. I don't know. I can't offer an explanation for that. It obviously clearly got to a point at this. It could possibly, obviously got to a point during this period in time where it was becoming unsustainable given the inquiries that we were getting, and I think we were needing to get on the front foot of it rather than just being constantly reactive to the whole issue.
And the idea in the email that a list of documents should be drawn up, was that something you'd been tasked with or something that you decided needed to be dealt with on your own initiative?
I can't say. I'm sorry.
Do you recall anything about how that idea came to arise?
I don't. I don't know if it was my idea or somebody or someone had suggested it. I really don't know. Can't tell.
This email suggesting a list of the documents is February 2006, 8th of February 2006. We know that the Bergen report on the Self-Sufficiency report was published at the end of February 2006. Did you have any concerns about the fact that a report had been written and was about to be published, but there were, it might be suggested, still ongoing concerns about documents, whether they were held or not by the department?
I can't recall it. I do know that in relation to the Bergen report, it was based on the documents that we did have and that had been assessed by Peter Bergen, who originally looked at the document. But I don't recall, I'm afraid.
Do you recall any discussion about it, saying we need a list, we're not really sure what we've got, what's been destroyed, but we've got this report coming out? Do you recall any discussion around those issues?
I don't, I'm afraid.
Then if we turn to DHSC 001 5858, please. And if we look at the bottom of the page, we have an email from the 21st of February 2006 from the litigation team. I write further to our conversation earlier and attach a copy of the letter received from Blackett, Hart and Pratt. You've stated in principle you have no objection to having the papers returned, though you'd like to see the letter before making a decision. Documents were returned to the Sol team from the solicitors who'd acted in the HIV litigation.
Correct.
And this is the email saying we've got the letter dealing with that. Before we look at the contents of that email, were there any discussions at this point again about we're about to get a whole batch of documents back from external solicitors and we've got a report coming out?
I don't recall the fact that these documents were coming in and the report about to be published. I'm afraid I don't know. I can't recall.
Do you recall any discussion about pausing the publication of the report to allow consideration of these documents?
I don't, but I do know that there was a lot of ministerial pressure to get the report published, given that it had taken so many years to get to this point of publication. So there was definitely that pressure. But I don't recall anyone saying, let's pause it because these documents are coming in.
And just in terms of the hierarchy of the department, would Mr. Conan have been aware of these documents coming back in?
Of course, yes. Mm-hmm.
And so whose decision would it have been if there had been a discussion to pause the report?
Williams ultimately, I think.
Looking at this email specifically, and the second paragraph particularly, you've stated in principle you have no objections to have the papers returned, though you'd like to see the letter before making a decision. I've been asked to ask you whether there was some reluctance on your part to receive the papers.
I can't say what I thought at the time, but given everything that was happening at that point in time, the knowledge we had about destruction of papers, I don't know that we would have had any reluctance. I don't know. I don't know if that's just perhaps a phrase Stephen has used possibly. I don't know. I can't see why we would have any hesitation, because I recall the reason we found out about these documents is because one of the campaigners brought it to our attention through correspondence, and we had then suggested to her to write to the firm of solicitors to make them available to the department. So then I don't see why we would have any hesitation to have these documents, because we encouraged her to write to get the papers back.
We can take that down now, Lawrence, thank you. In relation to the publication of the Self-Sufficiency Review, can you assist us at all with why there was such a lengthy delay between its commissioning in 2002, before you joined the team, and its publication in 2006?
We were not resourced at all in the team. As I said before, it was literally me doing the work with William there. There were other people in the team. So we did have somebody working on the blood directive. We had somebody at some point taking over the responsibilities I had on MSBTO, and we had a new committee. So there were other people in the team, but they had very specific roles. They were not related to the issues around contaminated blood products. But there were no other staff in the team.
Did you have any involvement in the report itself in terms of finishing it and finalising it?
I do recall having some. So I think my involvement on the report was, I think I contacted the blood service, Professor Zuckerman at the time, BPL, and also the UKHCDO. It was all very scientific. I was obviously of an administrative grade. It was kind of beyond my level of understanding a lot of it. So I would have, I think, sought input from them on some of the points in the report. I very clearly remember contacting them, and I think I assisted with some of the referencing of the documents as well.
And when you were contacting these external people, what were you asking them to do?
I think they were all aware of this report. It'd been in the team for a very long time. I don't know, there's no documentation which indicates. So I would have written to them, so I expect I would have filed my commissioning note to them, but I expect it would have been to comment in terms of some of the, I don't know if science is the right word, but just some, I can't recall, I don't want to put words in that, I can't recall from the time, but I guess they were the experts on these particular issues, so just seeking their advice on some of it. But
once the review was published, there were again a large number of parliamentary questions and freedom of information requests for the underlying documents, and you were involved in preparing the briefing pack for Lord Warner to respond to a starred question which Lord Jenkin had tabled. That question asked whether the report was a complete account of the circumstances leading to patient's infection. Could we look at that briefing pack, WITN 4912062? And if we turn to page 16 of it. We have the heading destruction of documents, and the point is, how can the report have any credibility when you've admitted that papers have been destroyed and the briefing pack provides an answer. We've always stated that the review is based on surviving papers. The report was commissioned to establish the facts around the achievement of self-sufficiency in blood products based on available papers, and then you deliberately destroyed documents. We regret that papers have been destroyed in error. There's been no deliberate attempt to destroy past papers. Officials have established that during the HIV litigation in the early 1990s, many papers from that period were recalled. We understand that papers were not adequately archived and were unfortunately destroyed following the litigation. Officials have also established that a number of files on the Advisory Committee on the Virological Safety of Blood between May 1989 to February 1992 were unfortunately destroyed in error. These papers were destroyed between July 94 and March 1998. Then if we turn the page, we have a potential question in relation to Lord Owen's papers. Just the second half, please, Lawrence. Why doesn't the report address the issue of Lord Owen's papers that were shredded? The review was never intended to consider why papers from Lord Owen's private office were destroyed. Papers kept by ministerial private offices are not kept after a change of government. If pressed, they're either shredded or handed back to the relevant policy section. And then if we turn to WITN 4912064, please. We have an email raising a query from Carolyn Flint's Assistant Private Secretary. It's at the bottom of the page. My only query related to page 20, destruction of papers from Lord Owen's private office. The answer, if pressed, states a private office will either shred papers or return them to the relevant policy section. My understanding, and what we prepared for during the last general election, is that private offices file all documents to be sent to DRO at Nelson. This could, of course, have changed from practices in the 1980s, but I think this needs to be double-checked. And we see your answer back on the first page at the top of the string of emails. It may be practice for private offices to send papers to DRO. However, my understanding is that at that time, papers kept by private office were either destroyed or returned to the policy section after a change of government. The line to take is based on inquiries that the previous head of the blood team made, following a statement from Lord Owen about the destruction of papers from his private office. Cabinet Office, Propriety and Ethics team has also confirmed that they are unaware of any guidance about the retention, destruction of papers in ministerial private offices once there is a change in government. That's your reply to the query. Had you contacted the Cabinet Office?
I expect I would
team?
have done. I think so.
A further questions were raised by Lord Warner, and the response to that is at DHSC 0041198_062. We see question and then answer, and it's been provided by William Conan. The first question, why didn't we check what papers the devolved administrations held when we found out we'd destroyed some files? I don't know, and there's no way of establishing the facts now. It appears that no one did think to check with DAs, which I agree was remiss. Do you recall any discussion around this time about that question of why papers hadn't been sought from the devolved administrations?
Don't know.
And then the third question, finally, PSPH is not convinced by the argument about destruction of documents from Lord Owen's private office. She said there surely must have been guidance from Cabinet Office. Isn't there guidance now? And the answer, private offices are not required to hold papers. All papers should be routinely either returned to officials in the department or destroyed. Cabinet Office have never issued guidance for that reason. I'm aware this is an email from Mr. Conan rather than from you, but did you have any further involvement in answering the question about private office papers when it came back again?
You mean this email?
Yes.
I don't think so. It's very much in William's style, so I think it's his form of words, not mine.
sorry, sir, I've got a reference that doesn't quite make sense in my notes. Can I just take a moment? Yes, here it is. WITN 4912066, please. Page 2. It's an email from Mr. Conan, to which you were CC'd, where he attaches a revised PQ and brief with the changes requested by the Minister. And then he wrote this: I remain concerned at the Minister's intention to announce in the House tomorrow that in principle we're not against the realising of documents used in the self-sufficiency review. As I mentioned this morning, this may well open the floodgates, and that would have a significant impact on our already stretched resources. The current FOI case has already been very time-consuming and is not yet completed. I'm also concerned that it will encourage similar requests which are not covered by the FOI provisions. When Scotland issued all the documents they released, I'm told, they had to employ additional staff at significant cost. Were you involved in any discussions about the possibility of releasing all the documents underlying the review?
Sorry, which review?
It's the self-sufficiency report.
No, not in that sorry, say the question again.
See, we can see here Mr. Conan is expressing concern about the Minister's proposal to release all the documents that underlay that self-sufficiency report. Were you involved in any discussions about that?
No, probably not, no.
Ultimately, the decision was that the documents would be released, but it took quite some time.
It did, yes.
Can you recall why that was?
Well, at this point in time, we were not sufficiently resourced, as William says, but by the time we did come to release the documents, we'd had additional staff in the team who were specifically dealing with that, plus other papers that we had as well.
A similar issue appears to have arisen in relation to resources relating to the solicitor files that were received from the external solicitors. On the 17th of May, you were told that the external solicitor files had been received, and you asked Mr. Conan what was to be done with them.
Right.
For the transcript, it's DHSC 5412535, and his response was that there needed to be a discussion about the need for additional resources to deal with them.
That's correct.
Is that also your recollection?
It is, yes.
There was then a story in the Observer and a question from Lord Morris questioning the department's stance on the documents, and a briefing was prepared. If we can turn that up, WITN 4912068, please. It comes from Steve Wells. What involvement did you have in this briefing?
Can you page up so I can see the rest of it, please? Steve was in a completely different team to me, so I expect very little. I expect I wouldn't have inputted to this.
In your statement, you say you don't think you were involved at all.
No.
We can see on page 3, we don't need to go to it, that you are in the copy list for it. What sort of recollection do you have of this briefing?
I don't know, I'm afraid.
If I may, we'll still just go through what's here and then look at another document, and then I want to ask you some questions about this. Mr. Wells notes that a briefing had been requested in relation to the story in the Observer, which argued as follows: until now, officials have always said an inexperienced staff member was probably responsible for the destruction of the files. However, in a letter dated February this year, Health Secretary Patricia Hewitt stated that under the Public Records Act 1958, all departments were required to identify records requiring long-term retention. Such rulings, she said, would be made by a senior member of staff. This statement is based, this is the explanation, this statement is based on a misinterpretation of a letter from the Secretary of State to Charles Clarke and appears to conflict with previous statements by ministers and officials that an inexperienced member of staff was probably responsible for the destruction in the mid-1990s of files covering the work of the Advisory Committee on the Virological Safety of Blood. And then we have the heading Key Messages. Decisions on retention and destruction of records may be made by relatively junior staff, IP2 or above. Line managers at all levels are responsible for ensuring that record keeping in their areas is consistent and meets departmental standards. This includes making sure that staff making decisions on records retention and destruction are sufficiently aware of the administrative needs of the section to be able to make the decisions. 7, there was no deliberate attempt to destroy past papers. And then it notes that an internal audit report had been conducted and led to improvements in guidance and procedures. And we see in 4 bullet points some of those recommendations. In this briefing, there's no suggestion that further work was required in relation to records, in terms of records that still need to be reviewed. Did you have any involvement in that aspect of this?
I don't think so, no.
There was then the meeting with ministers, and Mr. Conan followed that up with an email. If we could turn to that, WITN 4912069. At the bottom of the page, it's an email from Mr. Conan to Gerard Hetherington. That would be his boss.
That's correct. No, William's boss was Elsa, and Elsa's boss would have been Gerard.
So 2 layers up. And he indicates, following yesterday's meeting with Caroline Flint and Lord Warner, the following action is urgently required. And at the bottom of this page, we see destroyed documents. Although not explicitly requested, I think it would be helpful to compile a definitive list of all the sets of documents which have been destroyed. There are 2 sets, and we know more about one than the other. When they were destroyed, if we know, circumstances of destruction and likelihood of the documents which have just been found by the solicitors being copies of some of the destroyed documents. We have this info, but just need to pull it together in a crib sheet. We should also perhaps attach the list of documents, of which there are thousands, recently released by Scotland. We can just pause there. That idea of a list of documents was essentially what you'd suggested in February 2006, wasn't it?
It is, yes.
And between February and your suggestion and now, in May, are you aware of whether there'd been any opportunity to undertake that work?
I don't think there was, no.
We then have the paragraph relating to public inquiry. Ministers ask that we look carefully at the issues surrounding the continued and increasing requests for this, including the Scottish position. You mentioned the name of a departmental contact regarding inquiries, Richard Humphreys, and I think we need to speak to him urgently in order to establish exactly what we can should do regarding this, and establish just how decisions on inquiries are taken, costs involved, timescales, etc., as the pressure to hold one looks set to continue. Do you recall any discussions about this issue or any conversation with Mr. Conan about what had been discussed with ministers?
No, I think at this point it's clear to me that it has been escalated to Elsa and to Gerard. So I think I would have had very minimal input or discussion. It was clearly, we had this meeting with the ministers, we need to do something now. And it was Gerard and Elsa involved at this point.
And then we see in the next paragraph, documents returned to Sol. Ministers suggested that we could ask an independent legal expert to examine the returned documents and provide an initial analysis of what they contain. So at this point, those documents that had come in from Sol hadn't been analysed.
That's right, yeah.
And we can see from the documents that they were then sent out to council, to a barrister to be reviewed. And just for the transcript, that review is at WITN 4912073. want to then pick up with a series of correspondence arising from a letter from John Austin MP to Caroline Flint and forwarded to you to address. If we first of all look at his letter to Caroline Flint, DHSC 6548520, please. He says this: I appreciate that the government does not accept that any wrongful practices were employed, and I note your comment that papers were destroyed in error. Whilst I do not allege that papers were destroyed to frustrate litigation, I do not believe that those affected, and in particular the victims, will accept that without some form of independent investigation. I'm not necessarily suggesting a full public inquiry, but I think it could be in the government's interest, if there was no wrongdoing, for an independent assessment to be carried out. And then if we turn to DHSC 6548519, we have a background note. Do you recall your involvement in this?
I expect I would have drafted it.
If we just work through it, MSPH will be familiar with the request for the government to hold a public inquiry into the issue of haemophilia patients infected with hepatitis C through contaminated blood products. MSPH will also be aware of the sensitivity around the destruction of past papers on blood policy. In view of the parliamentary interest on this subject, we've recruited a member of staff to carry out a full examination of relevant papers, both registered and unregistered, to classify and record all the papers on this subject that are still in existence. Can you tell us who that was and what that was involving?
So by this point, we'd recruited Linda Page to undertake a review of all the papers and catalogue them as well.
And were you involved in that process as well, or was it left to her?
It was Linda, and I think she had someone called Patrick Hennessy helping her as well, but I wasn't involved in that project.
The third paragraph, John Austin's comments are very helpful. However, at this stage, we do not recommend that we give details about this work, as this may raise public expectation about the release of documents. Do you recall any discussion about this point, of whether there should be anything said publicly about the Page report or the work that was being undertaken?
I can't recall the discussion, but it's kind of like in keeping with the way government would work. You know, if you have a policy idea, you kind of want to work through it a little bit before you make a public statement about it.
And then just below that, we're currently considering the comments by MSR that we should use the powers under the 1977 Act for Secretary of State to commission a review of all the documents with a view to producing an independent legal judicial commentary on them and putting all these into the public arena. We were currently considering these comments, which we were informed about yesterday. Again, were you involved at all in any discussions about this proposal, this thought?
No, so this is... So the independent league, I don't recall this, no. I wouldn't have been involved in the discussions, so I expect I would have been given a line to put into this background note.
And where would that line have come from?
So can I just read it once again?
Yeah.
I expect there would have been a discussion about it, and I would have been given a steer to use these lines in this background note.
And who would that have come from?
It would have been with William.
And then just for the transcript, the reply that went to John Austin, or at least what appears to be the final draft, is DHSC 6548518. And it simply highlights that there has been an internal review in relation to the destruction of documents, and that documents were being disclosed. We're considering which documents could be released following the Bergin report. After that time, you've said in your statement that you became less involved in the document issues because Linda Page was dealing with that side of it. And ultimately, the work by Linda Page became the report entitled The Review of Documentation Regarding Government Policy in Relation to the Safety of Blood Products. You were involved in a couple of responses to correspondence and FOI requests, that I just want to go through to tie up the chronology. DHSC 0200132. I'm sorry, that's not where I intended to go to. Apologies. WITN 4912074. Apologies. In August 2006, The Observer had published an article stating that 45 new files had been found in the department. And we then have this letter from Linda Page to Lord Jenkin. And we see paragraph 3, with reference to the 47 files you mentioned, these are not newly discovered but have always been held by the department. Were you involved in this reply at all?
I wasn't, no.
And then if we pick up an email between Linda Page and William Conan, which you have CC'd in, DHSC 5435079. Linda Page is emailing William Conan. Lord Jenkin rang me today. I've briefed Zubeda on the conversation. He wants to know if the files he went through last time he visited are the same as the 47 we refer to. Told him I'd check with Zubeda and you when I got back from leave. He was okay to leave it till then. Liz's secretary is arranging a meeting of the project board for when I get back. We'll need to consider what approach is going to be taken to the Wellington House files, the 47. Those papers I reference in my report should be processed for release, but there will be few of these compared to the whole. Among the 47 files are some that were the subject of non-disclosure during the HIV Hep C litigation, about 4 files. I checked the status with Sol on Wednesday, and their view is that although they were previously withheld, they'll need to be checked to see if they should remain withheld. I've not read through them yet in detail, but a quick scan indicates that they're part of formulation of policy and could be withheld should any decision be made to release them. My own view is that we should apply Section 12 over £600 to any request made for bulk release. Firstly, is it right that these files, these 47 files, had been found in Wellington House?
That's correct, yes.
So although strictly they were always present in the department, they hadn't previously been identified as relevant files?
Well, I don't know, reading through these papers, it could be that these were, I think they were not in registered files, so I don't know that any of us, well, I don't know if I knew about them, although there's obviously that reference earlier back where I found 60, the folders, but by then we'd moved offices as well at this point, so it's very difficult to kind of really give a view on these papers, I think, because we had that move, and I was mostly working from registered files. I'd never worked from unofficial papers in the time I'd been in the team.
Do you have any clarity on what these 47 files were? Where they'd been found and how they'd come to be found?
I don't, I'm afraid. As I said, all the files that I was familiar with at the time these were found, we were in Wellington House, were registered files. So I'm not sure, I'm sorry.
And you said a moment ago you'd already found the 60 files.
Yeah, that was when we were in Skipton House. So during that period, we'd moved offices. So I don't know if these were the same files. I don't know, because they're different numbers. That was 60, this is 47. I was just really unsure when I was reading through my bundle of papers about the papers and the contents.
How much involvement did you have in the finding of these 47?
I don't think, I think it might have been Linda or Patrick found them. I don't think I was involved. Or I don't recall it at all.
And there's reference here to them containing, these 4 of the files containing documents that had been subject to non-disclosure in the litigation. Might these then have contained the documents that were thought to have been destroyed?
I think we can assume that there, yes.
If we then turn to DHSC 5154769, we have an email from William Conan to Elizabeth Woodson. It's the second paragraph I want to pick up. On the question of the 47 files, I'll speak to Linda once she comes into the office and we'll see what can be done. This whole area is far from straightforward, hence Linda's arrival to tackle it. I'm by no means certain that the 47 files were included in the Self-Sufficiency report, and I'm told they were not shown to Lord Jenkin either. The reason being that they're not actually registered files, but folders of papers which are simply found in a cupboard in the office. We'll need to word any response carefully, which is one of the reasons why I advised rushing against this one. They'd been found in a cupboard in the office. If there had also been a move from offices, did you have any involvement in their moving?
I mean, I can't say whether I specifically would have handled these papers. Normally, with all office moves, it's always a bit of a rushed affair. You're trying to, doing your day-to-day job and trying to prepare for a move, and you just basically get the papers and stick them into a crate, and then you unpack them when you get to the other end. I can't recall whether I would have been involved. I really don't.
This email was sent at 7:48 in the morning of the 9th of October. If we then turn to DHSC 0200135, we have a minute from William Conan up to Lord Warner, again dated the 9th of October 2006. And if we turn the page, we see conclusion. The 47 files have only recently been examined as part of this review when it became clear that they contain relevant documents. We are confident that they were included in the analysis for the self-sufficiency report, as colleagues who were present at that time recall seeing the consultants working on documents from the cupboard where the files were held, but we cannot be certain, and I've therefore not included this in the reply to Lord Jenkin. However, they were not made available to Lord Jenkin when he came to examine the registered files. This was simply because, as they're not registered files, we were not aware that they contained relevant information. You may now wish to invite Lord Jenkin to come into the department and examine any papers contained in these files which are relevant to his period in office. It might be suggested that there is a reasonably significant change between the email at 7:48 in the morning, which said that he was by no means certain that the files had been included in the self-sufficiency report, to this where Mr. Conan indicates that they are confident that they were included, but couldn't be certain. Do you know anything of what happened during the day that might have changed from a real uncertainty to a we're confident but not
I don't know,
completely certain?
afraid.
The Page report was published in May 2007, and then in July 2008 further documents were found. If we turn to DHSC 5533007, please. Email from Patrick Hennessy to Mr. Conan. And the subject of the email is litigation files found in well 517. This refers to the hanging file system at the entrance of Bay 517. It contains 41 folders of documents apparently compiled at the time of HIV litigation, 1989 to 1990. Some of it's out of scope of our review and disclosure of documents, i.e. it's later than mid-1986. However, there are papers from 1970 to 1986. Both Linda and I took a look and concluded that these appeared to be copies or top copies of documents that were contained in the Wellington and Solicitors file series, and that had therefore been redacted and released under FOI. Some of the earlier papers appear to be unreleased, but until they are inventoried and cross-checked, it's hard to say how many and whether they add anything to what is known. Neither Linda nor myself nor Laura has found anything in these folders from 1970 to 1986 that adds anything new. However, now that there is to be a public inquiry, I think we have to be absolutely certain. And then over the page, quite apart from the FOI aspect, the folders contain many top copies of e.g. correspondence with ministers and advice from DH solicitors. So this material really should be inventoried and put in new registered files. Laura estimates that she could inventory this material by the end of August. And then the next paragraph, there may be a question as to whether we should tell Lord Archer now that we are going through some old unfiled papers from the litigation period, and that if we find anything new and very relevant to his inquiry, we will let him know. However, this could simply get his team excited for nothing, as there is so far little sign that we'll find many, if any, papers that add to what he already knows. I'd be inclined to review the situation when these papers are inventoried. In relation to these documents, do you know anything about how they came to be found?
I don't, I'm afraid.
And can you help us at all with where and what sort of location the entrance of Bay 517 is?
I don't recall, I just don't remember. I mean, it was an open plan area, and there were lots of different teams. There would be lots of filing cabinets within the office separating the different teams. But that's all I can really recall of the layout when we were in Wellington House.
Subsequently, Mr. Conan wrote to Lord Archer telling him about the papers and noting the department's commitment to releasing the papers, and that the reference for that is DHSC 6700949. In relation to the Archer inquiry, we can take that document down, thank you, Lawrence. In relation to the Archer inquiry, in terms of decisions by the department about how and how much to engage with the Archer inquiry, what was your involvement in that?
I had no involvement.
Were there discussions within the team between you and Mr. Conan about how involved the department should be in the Archer inquiry?
I don't recall. Sorry, the only involvement I may have had would have been in response to any correspondence or PQs, because it was part of my day job, so to speak. But in terms of the decision making, I wouldn't have had any involvement on that.
And the inquiry is aware that there were meetings between the Archer inquiry team and the Department of Health, department officials. Did you attend any of those?
I did not know.
The final topic I want to discuss with you, Ms. Seedat. We've touched on a couple of PQs and correspondence which deal with the need for a public inquiry. And when you had a question or correspondence to answer, you've said in your statement that you simply used the line to take about whether there should be a public inquiry. You were asked in your statement about Andy Burnham's speech in the House of Commons, where he said there was a resistance in the civil service to facing up to historical injustice. And you were also pointed to Charles Lister's evidence that there wasn't resistance, but more an issue of groupthink. So the sense that when you work closely and collectively together, there's a risk of a group mindset developing. Can you assist from your perspective why you think infected blood issues weren't addressed sooner? Why some of the challenges weren't grasped at an earlier stage?
I mean, in terms of the policy team, I mean, I speak from my own perspective rather than from the team leader's perspective. But sometimes what can happen within a busy policy team, you're just so constantly reacting to events, to ministerial requests, parliamentary, etc., that sometimes there can be little scope to sit back for people to reflect on what the policy should be, or whether we should be looking at it from a fresh perspective, perhaps. So I think there's an element of that, certainly, and I've sort of seen it not just in blood, but also in other policy teams I've worked in. So that might be one of the factors, that you're just, because you're constantly under pressure. It's not an excuse, but I think it's a factor.
And might that, you talked about simply taking the lines to take from previous correspondence or previous answers to parliamentary questions. Yeah. What part might that have played in whether those lines were challenged or questioned?
I mean, I personally didn't challenge them. When Jill was there, those were the lines I used while she was in the team, and she was the one person with that corporate knowledge. I think there's a reference somewhere in an email to Richard Gutowski, the team lead at the time, where I've said to him, these are the lines on public inquiry. I've got them from the file and a submission to the permanent secretary. So I kind of, to me, in my, from my perspective, these are authoritative lines that officials and government are using on a particular area, and that's essentially why I would have continued those lines while I was in the team and not perhaps challenge them.
So those are the questions I have for Ms Seedat. We obviously need a little bit of time for recognised legal representatives to provide any further questions they'd like me to ask. I note the time, and I'm not sure, sir, I'm in your hands as to what you want to do.
Well, we plainly had to take a break.
Yes, indeed.
And it would be sensible, I think, to take a break and combine it with lunch.
Yes.
So the only question is whether you want an hour or whether you think we may need more than that.
So I don't anticipate needing more than an hour, no.
Very well. Well, what we'll do is we'll take a break now until 10 to 2. That's not before 10 to 2, just in case there are more questions than Council anticipates. And come back not before 10 to 2. If there's any delay, you'll be told. But I can't tell you how long you'll be kept after you come back. It depends how many questions there are.
Thank you,
not
sir.
before 10 to 2.